Hi y'all, and welcome back to the channel. I'm having some issues with my camera, so I'm going to continue with the style I used last time, and you will just be stuck with my voice. I've seen a lot of people talking about the 14th Amendment lately, and I wanted to address it. While it is something I end up covering with students just about every semester, it's a little weird to see it in the mainstream and being discussed in the context of current events and politics. I usually avoid political topics here because I do want to keep this channel history focused, but I've heard some egregious errors about the history behind birthright citizenship and why we have the 14th Amendment. Since it's unlikely we can send everyone collectively back to college to retake U.S. history, I thought it would be worth putting this out there and at least trying to provide the historical context for those who want it. Now, this is not me trying to convince you to adopt a particular political opinion. There are certainly times over this nation's history that we have changed how we do things through, for example, constitutional amendments, and we have the option of doing that again in the future if that's what Americans want. My goal is to educate on the history to maybe at least try to offset some of the false information that I'm seeing shared. I realize that people looking at the issue of birthright citizenship from a legal standpoint really only need to mention the 14th Amendment because that's kind of the most recent thing that affects it, but that's not the full picture, and I think it's contributing to this assumption that birthright citizenship only began with that amendment. So let's get into it. First, some terminology. Birthright citizenship is also known as jus soli, or right of soil. The opposite, where citizenship is based on the citizenship status of one's parents, is known as jus sanguinis, or right of blood. I've seen some people point out that birthright citizenship is not the norm around the world, and that's true, but I also think it's irrelevant. Since when were our founders trying to form a nation like all the rest out there? I'm not particularly concerned with how other places do things. I want us to focus on why the U.S. historically followed unrestricted jus soli and whether or not we think that's beneficial for us for our future. We didn't just think up this concept on our own, magically adopting it at the same time as our Constitution. Like so many of our laws, birthright citizenship was part of the English common law, and the founders retained that common law for the most part. Now, since that time, our countries have gone in different directions. Great Britain no longer has that, but we do. James Kent was a former judge turned the first law professor at Columbia University. He published a series of lectures, and one, published in 1827, is titled Of Aliens and Natives. He spends most of his time on the topic of expatriation, but offers a very simple definition of natives. Quote, "Natives are all persons born within the jurisdiction of the United States." End quote. Pretty simple. Then, in 1844's Lynch v. Clarke, the New York court determined that Julia Lynch was a U.S. citizen by virtue of birthright citizenship, even though her parents had only been visiting the U.S. and had then returned to Ireland, taking Julia with them. Even though she hadn't even grown up here, she was a citizen because her mother had been on American soil when she was born. Her status was really only at issue because of an inheritance question and because she hadn't remained here after birth. Typically speaking, birthright citizenship was just how it worked. Judge Lewis Sandford wrote in that decision, quote, "My conclusion upon the facts proved is that Julia Lynch was born in the state of alien parents during their temporary sojourn, that they came here as an experiment without any settled intention of abandoning their native country or of making the United States their permanent abode. They never concluded to remain here permanently, and after trying the country, they returned to their native land and there ended their lives many years afterwards." End quote. I think that's very important because sometimes when people are making these comments about birthright citizenship, they're saying, it only applies in this situation or that situation, but it doesn't apply any other time. And this case makes it very clear that it was completely unrestricted jus soli. If they were born on the soil, they were citizens, end of story. So after he set forth these facts, he went on and he said, quote, "It is an indisputable proposition that by the rule of the common law of England, if applied to these facts, Julia Lynch was a natural-born citizen of the United States, and this rule was established and inflexible in the common law, long anterior to the first settlement of the United States, and indeed before the discovery of America by Columbus." End quote. In working the Constitution into the decision, Sandford also explained this, quote, "The only standard which then existed of a natural-born citizen was the rule of the common law, and no different standard has been adopted since. Suppose a person should be elected president who was native-born, but of alien parents. Could there be any reasonable doubt that he was eligible under the Constitution? I think not. The position would be decisive in his favor that by the rule of the common law, enforced when the Constitution was adopted, he is a citizen." End quote. That's not the only case that can be applied to this question, but it is a key case, and I think it's a good example of the fact that birthright citizenship, like I said, was intended to extend even to cases where the parents were not even residents and were only here temporarily. This was the common understanding, but then a wrench got thrown into the works in the form of Dred Scott v. Sandford, a Supreme Court decision from 1857. This is what caused the 14th Amendment later on. To avoid any confusion, this is a completely different Sandford from the New York judge I was just discussing. Anyway, Dred Scott was an enslaved man who, along with his family, was taken by their slaveholder to live in Wisconsin Territory, a free territory. After Scott's later attempt to buy the freedom of himself, his wife, and his children was denied, Scott turned to the option of a freedom suit in order to achieve that end. This meant going to the courts and petitioning for their freedom on the grounds that the slaveholders had taken them to live in a free territory. Hundreds of freedom suits had occurred previously and been granted, but Scott's came at a time when tensions over slavery were increasing. His case went back to 1846, and the court granted the Scotts freedom. But then appeals went all the way to the Supreme Court, and the majority opinion issued in 1857 was not this country's finest hour. Chief Justice Roger Taney, writing for the majority, said that descendants of Africans were not citizens, so had no standing to bring a suit. He also claimed that the abolition of slavery deprived slaveholders of their property rights. Now, I don't want anyone to get the idea that the Supreme Court was universally racist at this time or wholly supported Taney's words. Multiple justices wrote dissents, including Justice Benjamin Curtis, who pointed out, quote, "Of this there can be no doubt. At the time of the ratification of the Articles of Confederation, all free native-born inhabitants of the states of New Hampshire, Massachusetts, New York, New Jersey, and North Carolina, though descended from African slaves, were not only citizens of those states, but such of them as had the other necessary qualifications possessed the franchise of electors on equal terms with other citizens." End quote. When he talks about other necessary qualifications there, he's talking about the early requirements in some states that you had to own a certain amount of property in order to be eligible to vote. This decision, Dred Scott v. Sandford, undermined birthright citizenship, something that had existed for our entire history as the United States, and it essentially added a racial requirement that was not there previously. Curtis, in his dissent, referred to native-born citizens exactly like Sandford had in Lynch v. Clarke, because that was just something that was understood, that being born on this soil and being free meant you were a citizen. End of story. The real issue with the Dred Scott case was the issue of, for slaves who later became free, did they then have the rights of citizens, or were things different because they had African origin? That's what I mean by adding a racial requirement. About a decade later, after the Civil War, Congress passed the Civil Rights Act of 1866. This law, among other things, stated, quote, that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, end quote. American Indians were a special case, and that would take a whole other video to explain. However, simply having parents who were citizens of another country, or being born while your parents were on vacation in the US, like Julia Lynch, didn't mean they were subject to a foreign power. That reference refers to people like diplomats, who are not subject to our laws, even when within our borders, because of diplomatic immunity. Whether someone is a U.S. citizen, a foreigner here on vacation, or someone whose parents came here illegally, ask yourself, could they be ticketed for a traffic violation? Could they be charged for theft? If the answer to these questions is yes, then they are subject to our laws, despite what country they are technically citizens of. Now, the Civil Rights Act of 1866 was intended in part to overturn the bad precedent that had been the Dred Scott case because of that racial element. Then President Johnson vetoed it. Congress overruled his veto, but to further enshrine these rights and ensure that there were no questions about it whatsoever, they passed the 14th Amendment with its citizenship clause. However, the 14th Amendment did not create birthright citizenship. That's something I think many people are missing in these discussions, and I get it. Even some of the congressmen who passed the 14th Amendment didn't fully understand what the standard was prior. At the same time, with the exception of the Dred Scott case, which, like I said, that the racial element is the issue there, with that exception, it is clear that our judiciary did consider birthright citizenship to be well established. And that's not to say issues of citizenship have been smooth sailing in this country. Different ideologies in our past have repeatedly complicated the issue of immigration and who could be viewed as citizens, from the Chinese Exclusion Act to internment of Japanese Americans during World War II. However, none of that changes the underlying precedent in the common law used at our founding. I hope y'all found this interesting, and I'll talk to you next time.